Hi, and welcome once again to AskCred Knowledge Series 5. Thank you all for the lovely feedback and suggestions that you all have written, and glad to know that these knowledge series are proving useful to you all. In line with the same, I feel very excited to cover today's topic: bad debts during COVID. How bad is it really? Not only because this is one of the most sought after query today, but also because we bring to you one of India's leading legal experts and also my dear friend, Mr. Adab Singh Kapoor, with us today to answer and guide us with the best suggestions in the legal framework. Welcome, Adab. Advocate Adab Singh Kapoor is the founder and proprietor of Adab Singh Kapoor and Associates, which is a corporate and litigation advisory firm in Delhi. Adab Singh Kapoor is also advisor to companies and NBFCs and a qualified company secretariat. Throughout the course of the lockdown, on account of the COVID 19 pandemic, Adab Singh Kapoor and Associates have been representing and advising clients across various verticals on issues relating to force majeure events, payments of salaries and wages, related benefits, rental, financial implications of the pandemic on businesses, performance of contracts, and such other allied matters. Welcome, Adab.
Thank you so much, Aarti, for having me over for this knowledge series. And congratulations for all the good work you're doing in this regard.
Thank
Yes.
you, Adab. So let's just quickly get started. We have a lot of questions that have come in from a lot of borrowers, and I thought it would be nice to have you through a virtual conclave and where we could address some of these questions, at least try and attempt them today.
All right, let's go ahead.
Right.
Yes.
So to start with, other there are several consequences of default, social stigma, a bad civil score, etc. But from a legal perspective, what are the consequences of default?
Well, if there's a default, in many cases there's litigation. That's one. So the types of litigation which generally ensue if there is a default is the person who's the lender. He may initiate civil cases for recovery of money. It could be a summary suit. If a check is involved, there could be check bouncing cases. Now, also in the event there is a misrepresentation or a deception practice, there could also be a criminal angle attached to it. So these are regular cases which are tried in courts in the event there is non-payment of money on default. Also, in the event there's a bank which is involved, they could take action under the SARFACI, also under the Recovery of Debts Due to Banks and Financial Institutions Act. And insolvency and bankruptcy code can also be invoked in appropriate cases of default. So these are the cases generally which happen. But the important thing to understand is in the event there is a decree or there's an order of the court, and that particular order can be executed. And for the purpose of execution, it could even mean that the property of the borrower or the defaulter can be attached. In appropriate cases, it can also be a case when they are sent to prison. A receiver is appointed, etc. So then those are the hard facts in the event the execution proceedings are initiated.
So you're saying basically that a guarantor can also be made parties to such cases.
Yes, because in the event there's a tripartite agreement, and in the agreement between the bank or the borrower and the guarantor, in the event the principal borrower is not able to pay, the liability of the guarantor is runs coterminous with that of the borrower. And yes, the guarantor can also be proceeded with in such scenarios.
All
I
right.
just like to add because I'm really intrigued because you spoke about CIBIL scores. Now the point here is that in the event there is what recourse which people can do in the event their scores are falling.
Yes.
Uh, in the event there is an appropriate case where there's a dispute. Now, in the event, in the case, normally when we do cases with builders, when we have a particular a lottee who has entered into a tripartite agreement with the bank, and then the builder stops constructing, the bank continues taking EMIs from the allotee. Allotee says, why should I continue paying money when there is no property in sight? and the matter is in the insolvency court. So and the credit score keeps falling because of the non-payment of EMIs. In such cases, a representation can be made to the CIC, Credit Information Company, as well as the credit institution, for incorporating an appropriate remark that there is a pendency of a dispute.
Okay, so what are the reliefs or the legal recourses available to individual or borrowers, who are not able to pay their restructured EMIs? A lot of borrowers will now start restructuring their loans with good intent, but there could be scenarios that they're not able to restructure their EMI, pay their restructured EMIs. What are the recourses available for such customers?
Yes, RBI is coming up with several schemes of restructuring of loans, and also banks have been trying to speak to customers of how they can restructure their loans. But for certain industries which are really badly hit, for example, hospitality, tourism, and aviation, and such industries, for their restructuring, sometimes the bank may not be wanting to restructure, or the restructuring may not be very uh, practical even in this scenario. So for them, they can always try to plead that impossibility of performance of the obligations in the contract. For example, if there's a loan agreement, and even if the loan agreement does have a force majeure condition, or even if it doesn't have, if it is an impossibility of performance because of the COVID pandemic, especially for industries like this, and even otherwise, it depends on the facts of the case. If a particular individual or a company can establish that on account of COVID pandemic, the work has suffered so badly that they cannot repay their debt or installments or service their EMIs, then in those cases they can in advance send them a notice and say that this is the problem. We will need so much time. They could enter into negotiations and discuss how to restructure. Even after restructuring, if it's still not possible, they could still say it's impossible to perform. And in the event litigation starts from the side of the from the lender or from the person who money is owed to, then it could be a strong defense if from the facts of the case they can show that in this kind of scenario, this contract should be rendered impossible to perform for this period. So
Okay.
that could be one recourse which could be taken. There are other further recourses also, which, of course, if the situation is so bad, then of course you can move towards insolvency. Uh,
Right. Sure, I will cover up certain questions on insolvency because that is also another
and I'll
query
end
that
at that.
people have come. Meanwhile, Adab, the RBI regulatory measures have been under criticism for being very unclear on a lot of issues, right? What is the legal position as of now with respect to the enforceability of such issues?
Well, one such issue is the interest on delayed payments during the moratorium.
Yes.
Now, that matter is sub judice before the Honorable Supreme Court. In fact, the Honorable Supreme Court is monitoring this matter, and the issue of compound interest or interest on the delayed payments is still not very clear because RBI has not come up with any circulars to, they have filed an affidavit, the Union of India has filed an affidavit in the court, but it's still not clear exactly whether the terms have been implemented, and if yes, across which sectors, is it across all sectors or specific industries? So this clarity has to still come along. But the one good thing which, and there's several writ petitions in the Supreme Court on this point challenging the RBI's notification in this regard. But the good thing I would say for which may help the defaulters or borrowers, that the RBI, the Supreme Court has said that with respect to accounts being NPAs, and to that extent there is some sort of a relief for all accounts which were not declared to be an NPA by 31st of August 2020 will not be declared NPAs for till further orders of the court.
Okay.
So yeah,
So you're saying the accounts of defaulters will not be declared as an non-performing asset.
further orders of the Supreme Court. Yes. So this
Okay.
is a relief for borrowers. And if the accounts are not declared NPAs, now certain measures under the SARFAC, which is when the account is declared as an NPA and then attachment happens, the property, etc., those measures will not be taken as of now. So
Okay.
that is a major sigh of relief for people who are actually and genuinely suffering on account of the COVID pandemic.
Yes, indeed. I think that is a relief. Adam, a while ago, you just mentioned that a lot of industries like tourism or hotel or restaurants, etc., notwithstanding the restructuring facilities available to them, these kind of businesses may still find it difficult to survive and may not be able to pay their EMI. Now, in such cases, you said that they can file for bankruptcy. Could you just elaborate little more on this? That how does a small business like this file for bankruptcy in such a case, and also can an individual file for bankruptcy?
All right. So yes, now fortunately or unfortunately, the CIRP, the Corporate Insolvency Resolution Process, has been suspended by the Ministry of Finance during the COVID pandemic. But for individuals and also such businesses, for businesses rather for companies right now, in the event they feel that it is not sustainable for them to proceed and they can't go under the insolvency route under the IBC, they can go under the Companies Act under Section 271 and 272 in an appropriate case to say that it is fair and equitable for them to be wound up in such situations because of the fact that they are not being able to proceed further in the line of work which they are doing. And for individuals, though the IBC Part 3 has not been in, is not in, is applicable as of now, it's not enforced yet, which talks about insolvency for individuals. But the Presidency Insolvency Act and the Provisional Insolvency Act, which are century-old legislations, they are still in force. And in cases when there is absolutely no respite and the companies or the individuals, sorry, have to file for bankruptcy, they can file under these enactments upon which an official assignee or a receiver will be appointed and their assets, whatever they have, will be appropriated towards their creditors in the priority list. So yes, it is a possibility, but I would still suggest that on first blush, it should always be the case that they should try for restructuring and plead impossibility of performance. And I'm sure that in a genuine case, and if it can really be established that yes, this business was really affected on account of the pandemic, then the court should exercise their discretion in a manner favoring such genuine cases,
Right.
invoking the equity relief for the court. Yes,
So I think
because insolvency is at a stage when it's the last resort. So it's better to explore other avenues first till you come to the last stage. Yeah.
right. I think one important takeaway that I just took away, from your answer response is that they have to really prove the genuineness of the impact,
Yes.
uh, right, before they can even plea for an impossible payment scenario,
Yes,
right?
it would be a malified intent that you cannot be just everyone says COVID is there, force majeure condition has to be taken for granted. That's not the case. It has to be seen on every fact or in every single case has to be seen from his own individual lens how it is.
Correct.
So that is how the courts will look into it.
Now, the corona pandemic is a once in a lifetime event, right? One can easily argue that the law of the land required people to stay at home. And is there a cause for customers to argue for force majeure and postpone their payments in such a scenario?
Well, this is what we have been receiving so many cases during the lockdown on different aspects of how to invoke force majeure, whether their business can invoke force majeure because of such conditions. The point here is that again, at the cost of repetition, that it will depend on every fact and situation. Every case will stand on its own legs, and the force majeure condition, it cannot be that taken for given. Just merely a difficult or uneconomic performance is not sometimes sufficient to qualify as a force majeure condition. Uh, Lockdown cannot be, some judgments have come in during the course of the lockdown, in which the courts have said that lockdown cannot come to the rescue of the petitioners or just to retire from their contractual obligations. The courts have also said, this is a recent Delhi High Court judgment, that the conduct of the parties have to be seen. It also has to be seen that what were the conduct of the parties before the outbreak of the pandemic, what were the deadlines that were imposed in the contract, whether these deadlines were supposed to be finished prior to the outbreak starting, the steps that were to be taken, the various compliances that were required to be made, and only then assess as to whether genuinely a party was prevented to fulfill their stipulations or not because of the pandemic. So, yes, it has to depend on which case and what are the facts and circumstances of the case.
Okay. Is it also necessary to specifically have a force majeure clause in a contract for a party to invoke force majeure?
Uh, Not necessarily, but the point is, in the event there's no force majeure clause, and you can, in that case, plead for frustration of contract, which means that it is impossible to perform the contract in account of the peculiar facts of the case of the person who wants to claim frustration of or plead frustration of contract. So, in such cases, in the event it is proven that their business was such, like for example, tourism or hospitality or the airline in that particular situation, and that they could not at all carry on their work or business, then they could plead frustration of contract because it was impossible. But again, the test is on a higher pedestal. The courts uh, try and attempt to strictly interpret these terms, and it will have to be proven really whether it is a genuine case or not. Yes.
All right. And a lot of questions have been floating around rent and lastly, whether a tenant can seek suspension of rent, whether it's a residential or a commercial arrangement on account of COVID-19.
See, Aarti, even the rent issue is a contract issue. Now, in the event in the contract, there is no particular provision as such
Yes.
that in the event pandemic happens and then you cannot pay rent. So then obviously it cannot be interpreted that a force majeure condition for a pandemic exists and the tenant will not have to pay rent. However, again, as I said earlier, even if there's no force majeure condition, if you can generally impossibility of performance will not be applicable for tenancies for temporary non-use of the premise when the tenant says that I cannot pay. So the judgments have been mostly on the point that no, in such cases, the tenant is required to pay the rent and cannot invoke frustration of contract or impossibility of performance. However, what we have seen during the course of the lockdown is that most of the cases, the tenant and the landlord, they enter into an arrangement which is mutually acceptable to both of them, and either they enter into an addendum to their lease agreement or they enter into a fresh agreement. So that is something, of course, which is happening practically on many cases. We have seen this happen.
Okay.
Also, the Delhi High Court has recently given certain reliefs, on equitable measures. So that can also be seen. The court has to see in appropriate cases that whether the equitable jurisdiction of
Mhm.
the court can be invoked in an appropriate case where there has been non-use of the premise. So again, it how you plead the case. How do you show? For example, if the premise is not being used at all for 6 months, 8 months, and because of which reason that business had to shut down, so in such a situation, then the party can obviously try and say that this was something which is totally out of their control, and they can plead for impossibility but technically the judgments are clear that you cannot do so, but they can speak to the landlord and try to see how they can equitably handle the situation.
Right. So while the judgments do not really support the same, I think
Yes,
a discussion, a mutual
that's
way is
definitely
what can. Um,
because both the landlords and the tenants they're trying to meet midway in such kind of situations. But again, it depends on the kind of equation they both share
right.
also.
While Adab, you've really helped answer a lot of questions. I think what is the one last piece of advice or suggestion that you would like to, maybe in a summarize for all the borrowers who, would be watching this video?
So my main point here would be to whoever is not being able to fulfill their commitments, I think there is still enough measures which the government is trying to provide. The courts are also very mindful of the fact that people are suffering. So rather than proceeding to say that there's bad debt and what do we do, there is definitely a lot of ways in which you can turn around and get the benefit of the schemes and policies, as well as the judgments which are being passed in various cases. And there is not a real need to worry too much that this is doomsday and nothing really can work around this. So I think you have to be positive and use the measures which are available to you to come out of the situation.
Thank you, Adab. I think you've answered our question of the topic, right? Bad debts during COVID, how bad really it is. And
Not very bad. And they're not really bad. I'm sure there are ways to make it look not so bad. Yes.
right.
And feel
Um,
not so bad.
right. Well, this has been a very interesting session today with lots and lots of meaningful insights. Thank you, Adab, for this wonderful virtual consultation and look forward to many more such interactive conclaves with you. Thank
Thank you so much,
you.
Aarti. Good work. Thank you.
Most
Yes.
welcome. Thank you, viewers, for watching. And if you have liked our video, do send us a like and also subscribe to our channel if you haven't as yet. We shall be back soon with many more such interesting topics soon. Thank you so much.